Good afternoon, everybody, and welcome to another webinar from the TUC. My name's Anna. It's great to see so many of you joining us already. We're joined today by Sally Buffard from the Labour Research Department, and I'll be introducing her shortly in more detail. Just our usual housekeeping before we get going. We do have live captions on today's event. There's a green button underneath the video. If you click that, it will open a new window with live captions in it. If you want to have the live captions alongside the video of me and Sally, you'll have to resize your screen, your web browser screen, so that you've got them next to each other. So please do that if you like. We will, as always, be recording today's event. So if you miss anything, don't worry, we'll send you a link to the recording. Sally's also got a useful handout that will mention case law and other useful resources. We'll make sure that's sent out to you all, along with the recording, either later today or tomorrow. We will be awarding a digital credential to everyone who's on this webinar live, and that will be evidence that you've attended today, and it will include information about what you've learned. You can share this credential with your union, with your employer, with your members, and show them what you've learned about redundancy law and how that helps you as a rep. So do look out for that. It will come via email later today or first thing tomorrow. If you find the chat panel, which is on the right-hand side, a little bit distracting, because we know that it can be sometimes, you can switch it off from view. So all you need to do to switch it off is click the white speech bubbles that are to the right-hand side of the chat panel, and that will switch the chat on and off as needs be. But we do know also that you really like using the chat, and we love seeing you exchange ideas and tips from your workplaces. So if you want to, please do that. Okay, we're going to be hearing today from Sally Buffard from the Labour Research Department, and the TUC do a lot of work with the LRD, so it's great to work with them again on this issue. And Sally is going to cover three main areas. But first, we're going to go right back to basics with what does the situation look like. So Sally, over to you.
Thanks, Anna. Hi, it's good to be here, and it's good to see people in the chat. Hi to everyone wherever you're logging in from. So I thought I'd start today with just basically defining what is a redundancy. Now, the main redundancy definition is found in section 139 of the Employment Rights Act 1996. It says that a redundancy is a dismissal where the employer has ceased or intends to cease to carry on the business for the purposes of which the employee was employed, or to carry it on in the place where they were employed. Or secondly, dismissal because the requirements of that business for employees to carry out work of a particular kind, or for employees to carry out work of a particular kind in the place where they were employed, have ceased or diminished or are expected to cease or diminish. So what that means is that there are three scenarios that give rise to redundancy. Those are the business closes, the business relocates, or the employer decides it needs fewer employees to do the work that they were employed to do. Now, the first two of those are probably easy to recognise and don't cause too many problems with definition, but the third one gets a bit complicated when employers are restructuring or reorganising. So that's where the employer just says it needs fewer employees. So I've put together a few cases with examples of scenarios that will amount to a redundancy, because it's not always easy to define. Now, as Anna said, I've done a handout here, so you don't need to worry about writing down the names of the cases. All the cases that I'm referring to are on this handout, and you'll get a copy of this after the webinar. But the first one is where the work stays the same, but the employer decides to use fewer people to do the work. So they decide that there are efficiencies to be created by reducing staff. So the example here Kingwell and Elizabeth Bradley Designs is a company that made sewing kits that are sent out by mail order. Now, it made some changes because it was having a bit of difficulty with sales, and ended up employing 10 staff 1 day a week each. And then shortly after that, they decided that actually that wasn't very economical because they had a lot of admin costs and it was just disproportionate to the number of staff they had working. So the level of work stayed the same, but they reduced the number of staff to 4 job shares. Now, that is a redundancy situation, although it's exactly the same work because the focus is on the number of employees. Another common example is where there's a slight change in the job roles. And the 2 examples here, Murphy and Epsom College is the first. The college employed a plumber to do general plumbing work, and then subsequently employed a second plumber to maintain the heating system. It then decided it actually only needed 1 plumber, and so they kept the second plumber who it had recruited. And that was a redundancy because the needs of the business had changed from a plumber who did a bit of heating engineering to a heating engineer who did a bit of plumbing. But again, it was about the number of employees who had reduced. The seminal case here is Safeway Stores and Burrell, where Mr. Burrell was a petrol filling station manager at one of the Safeway stores, and Safeway's decided that it had too many managers overall and it was going to reorganize the whole of its work to get rid of some managers, and they got rid of his role and they had instead a petrol filling station controller who reported into one of the other managers. Now, it was similar work to what he was doing before. He didn't want it because it paid about 15% less than he was getting. But after he was made redundant, he challenged it in an unfair dismissal claim because he said that the new person was doing exactly the same job that he had been doing for just less money. So he said that's not redundancy, that's just cost saving. But actually what the EAT said, that does meet the definition of redundancy because they decided that they didn't want to employ managers at a management grade. They wanted employees at a lower grade, at a lower rate of pay, and that was a legitimate redundancy situation. And I think that's quite a common situation. You get members saying, well, they got rid of me, they said my job had gone, I took redundancy, and then I find out like 3 months later that someone else is doing exactly the same job, so I'm not redundant. And it's really crucial that you look into all the steps, what actually happened. You need to identify what employees there were and what has changed, because clearly if it's exactly the same job, exactly the same terms and conditions, nothing has changed, then that's not a redundancy because there's still a requirement for the same job. But a reduction in pay is a legitimate redundancy exercise. And this focus on the number of employees rather than the job to be done is the reason why bumping is lawful. And bumping is where the employer establishes that redundancies need to be made, but wants to retain particular skills or experience. So it gives someone else's job effectively, and that someone else is then made redundant. So their job remains needing to be done. So they still need the job to be done, but they don't need the same number of people. And that's why it's crucial that you look at the number of employees, not get bogged down in what type of work they do, because that's what a tribunal will look at when they're looking at the definition of redundancy for those purposes. There was an issue for a while about situations where an employer needs somebody part-time instead of full-time. So you've got a full-time person working there. The employer says, well, actually, we've got some changes in technology. We don't need somebody for the full hours now. Is that a redundancy situation? And there were lots of decisions that said, actually, it's not, because you've still got the employee. But this key decision in Packman and Fauchon, which is on the sheet, says that actually that can be redundancy, and that's a really important case for arguing that, you know, somebody is entitled to redundancy even though that part of their work remains. So it was about a bookkeeper who her employer said she didn't need to work so many hours because of the changes in software. She refused to cut her hours and they dismissed her and they wouldn't pay her redundancy, but she won her case. The EAT upheld her claim for redundancy because the need for bookkeeping had diminished by number of hours. And effectively what it did, it looked at it in terms of the fixed term equivalent hours rather than the total number of employers. So it was a bit of a departure from previous case law, but it's a useful case to have. Change of location is a little bit vexing because there's a tendency for employers to put these flexibility or mobility clauses in a contract that says basically if we move you have to come with us. It's still the same job. Now on the whole, tribunals take a bit of a dim view of that, and there are two very useful cases, the High Table and Horst and Bass Leisure and Thomas, which said that the employers couldn't force people to move in those circumstances, that a change of location that was really significant was a redundancy situation and they didn't have to go with them. And then unfortunately, the Court of Appeal in the case of Home Office and Evans went the opposite way. So staff had to move from Waterloo Terminal to Heathrow, which was, you know, a huge location, involved a lot of extra time. And if they didn't move, they were dismissed. And the Court of Appeal said there's no redundancy there because they had clear terms in their contract that said they were required to work wherever they were required. And so it was a dismissal for conduct for refusing to move rather than for redundancy. So we do have that rather unfortunate case there, but there are equally cases where tribunals are saying, well, employers can't just use a redundancy to make people move wherever they want to. So you can challenge it, and those two cases are really good cases to challenge those. Even if the mobility clause is quite clear, you can still challenge it. Sometimes there's no dismissal, but employers will try and change terms and conditions quite radically in a restructure. It's what we call fire and rehire. So the job is still there, but it's changed to such an extent that it's not the same job that people were doing. It's either less money or it's a different location or it's slightly different duties. Now, it's difficult to challenge that and certainly under the ERA definition of redundancy, that's not going to count because there's no dismissal. But for the purposes of collective consultation, so if it's in a workplace where 20 or more people are affected, then you can actually challenge it using the collective redundancy consultation terms, and that is because the right for a union to be collectively consulted over redundancy comes under Section 188 of the Trade Union and Labour Relations Consolidation Act, or TULCA, and that uses a different definition of redundancy, which is a dismissal for a reason not related to the individual concerned. And the leading case there of GMB and Man Truck and Bus UK established that that applies when you change, an employer changes terms and conditions so much that effectively it's a dismissal and re-engagement on new terms. And that allows you to challenge changes to terms and conditions using redundancy law. And the scope for challenge is much wider because there's a lot of case law now on what is required in collective redundancy. So there's a list of things that have to be included. It has to be about avoiding dismissals. And remember, we're saying a radical change to terms and conditions is a dismissal, reducing the number and mitigating the consequences. And it's well established now that consultation has to be sufficient and meaningful, in good faith and not a sham, It has to cover business reasons for any proposed change, and this is where it's much wider than the ERA definition, because tribunals will very rarely challenge an employer's decision to make redundancies to cut costs. It will accept that it has, leeway to do that, but with collective consultation, they have to discuss that with you, and unions are entitled to see the business reasons and entitled to challenge them and come up with alternatives. So it's a very useful step when you're faced with substantial cuts to terms and conditions. Obviously, any redundancy procedure has to be fair. Even if there's a fair reason for dismissal in the context of a redundancy, so you've established that there is a legitimate redundancy, an employer can dismiss by reason of redundancy, they still have to follow a fair procedure, or else it will be an unfair dismissal. And there are established procedures that apply in all redundancies, which were set out in Williams and Compare Maxim, which reps will probably have heard of. It's an old case, but it's the go-to case still, and you'll see lots of cases on redundancy referring to these principles, which are to give as much warning as possible, consult reps, draw up agreed selection criteria, use objective selection criteria, carry out the selection exercise fairly, consider representations, and offer alternative employment where possible. And even when there's no actual entitlement to other work, the scope for alternative employment is quite wide. It depends on each particular case, obviously, but recently we've had a case come through the EAT now relating to coronavirus, where it was unfair for an employer to dismiss somebody without considering first furlough. So obviously there's no statutory duty for employers to do all of those things, but because those principles are so well established in case law, an employer that doesn't follow them is going to fall foul of unfair dismissal law. So you've actually got quite extensive reasons there that you can use to challenge a redundancy situation and get employers to consider alternatives. And I wanted to mention briefly also that it's become quite common practice now for employers to get people to reapply for existing jobs. And certainly in public sector, it seems quite a common thing to do now. And unfortunately, it's not necessarily unlawful. There is this case, this Gwynedd Council and Shelley Barrett and another, that went to the Court of Appeal that said it should only be used when a restructuring creates genuinely new and different jobs. That it's not a very well respected practice, and so it is open to challenge at the early stages. The usual standards of fairness still apply, so all those principles that were set out in the above case will apply in terms of looking for different jobs, looking at different ways of mitigating dismissal. And that should only be used in specific circumstances where they are genuinely creating new jobs, not as a way to get people to just reapply for their same job. And I did see, Anna, we had some questions already about those. So I don't know if you want me to take those now.
We can. I think maybe let's finish your talking about the generalities, fair procedures, ways reps can challenge the situation, etc. And then we'll come back and we'll take questions then rather than doing them now. Yeah, feel free to rest your voice. Have a glass of water. I'll just remind any viewers who have joined us a little bit late that you can post questions for Sally in the Q&A panel. It looks like a speech bubble with a question mark in it, and you open that panel by clicking on that icon on the right hand side of the screen. So feel free to do that, and we'll get to as many questions as we can. Also, a reminder that we will be awarding a digital credential for viewers of this webinar. If you're watching us live, we'll send you the digital credential later today or tomorrow, and it's evidence of what you've learned today. And also, before I hand back to Sally, we want to tell you about an event that we've got coming up in the next few weeks from the TUC. So some of you may remember a month or two back, we had a webinar like this that was about preventing burnout for workplace reps. And it was delivered by someone called Miriam Fine, who we've done a lot of work with. It was very popular, and we got a lot of requests for a fuller session on what she covered. So Miriam is going to deliver a one-day workshop for us on July the 18th. We will post a link to how you can register for that in the chat. If you miss the link, because it might move quite quickly, we'll make sure it's included in the email that gets sent out later. But I'll remind you of all this later on in the broadcast. Right, that's enough from me for now. Sally, back to you, of where we got to with challenging redundancies and fair procedures.
Yeah, thank you. So I just wanted to finish by saying, so basically in any redundancy situation, the way to challenge is through an unfair dismissal claim. And so you're looking at all the factors that make dismissal unfair. One of the key factors will be whether there is suitable alternative employment and whether it's reasonable to take that. So there are several instances where you get, certainly it's not uncommon for new jobs to be created, and somebody in the existing role to be offered a new job and told that it's virtually the same as the other one, and if they don't take it, then they won't be made redundant. So we've got this case here, Hackey and Instinctive Partners Limited. So this was an HR administrator who carried out HR admin tasks, and she was also working as an assistant to the CEO and finance director. And the company decided to restructure, and there were two posts created. One was an HR advisor, one was a PA to the CAO and financial director. So that was a redundancy situation there because there was no longer a requirement for her old job. There were two jobs instead. But we had a case with a very similar situation. So you had somebody who was working for one person, doing lots of different roles. The role was split, and she felt that she had effectively half a job, and she didn't want to take that job. But if she refused it, she wasn't entitled to the redundancy pay. And one of the key things that tribunals will look at is they'll go. It's not enough just to have a different job title. They will go through the various types of work that have to be done. She ended up losing her case because the company had offered her a trial period and she didn't take it. And it's really important for members to recognise that it's an opportunity to establish if there is a difference or not in the cases. Because if the employer offers you an alternative job that is deemed to be suitable and you unreasonably refuse it, you do lose the right to have a redundancy payment at all. And it is important to spend some time analysing what's actually on offer. And equally, people who get in these restructure situations where they're having to apply for other jobs and it's not their own job, it's got bits and pieces of the other. Employers have quite a wide remit to change the role without it being effectively a redundancy situation, and that's where a lot of the difficulties arise in these restructuring situations. So another major reason for going through the collective consultation route is that it gives you a right to look at alternatives to dismissal that you don't get to the Section 139 definition. So that can be really open-ended, and the more information you can put together and the more alternatives you can put together, the greater your chances are of avoiding redundancies and winning a potential claim. And I just wanted to stress really how much you have to analyse it step by step to do a comparison between the existing jobs and the new jobs. It's not enough to just say, well, there's lots of different elements. It can still be a suitable job, even though there are bits of it that you didn't do before. There's quite a lot of scope for employers to restructure on quite a wide basis. So I think that's the bit that I wanted to cover, Anna. And if you've got questions on it that I can come back to, I've seen already in the chat there's quite a few cases to get into.
Absolutely. I think that was a fantastic overview, Sally. Thank you for that. I feel much more knowledgeable now about situations and how we can challenge it. I'm just looking down at the notes I've made during the presentation. You're right, we've had quite a lot of questions come in. So I'm going to try and group them so that we can get as much information to as many people as possible. And just a note to the audience, if we don't ask your question exactly, we do try and include it in another question. So we ask Sally to talk a bit more generally about something, and we take all questions into consideration when we're putting guidance out for union reps. Please don't think we're not reading them. Okay, can you talk a little bit more, please, Sally, about what selection criteria might be? You've already referenced it, but what are some examples of selection criteria that an employer could use and that would be deemed fair?
Selection criteria can be, well, they need to be objective if possible. So it needs to be things like time spent in a job, skills acquired, experience. You have to be careful. So last in, first out used to be a valid selection criteria, but now it tends to be age discriminatory, and it's something that should only be used as one of a number of different selection criteria. So things like number of skills required. So in some jobs, it's appropriate to look at which different parts of the job you've been trained in, what training you've received, what skills you've had, how many different aspects of the job you've done, what your transferable skills are. Performance is one that's quite often included, but it's subjective. So generally the rule is, if you're going to involve subjective criteria, it should be one of a number. You don't want to allow one manager to influence totally the scores, because it becomes subjective then and potentially discriminatory. And it's also important to recognise that things like sickness absence, while they are used as a selection criteria, you should always adjust them to take account for absences that are maternity related or pregnancy related or related to a disability, to remove the discriminatory content of that.
Thanks, Sally. That's really helpful. Okay, we've also had a few questions talking about suitable alternative roles. So can you talk a little bit more about those, please? For example, if someone feels that that something isn't a suitable alternative role, but it's the same grade, for example, where would they stand? What determines that something is suitable as a job?
Well, the suitability, again, this is the objective part of it. So it would look at what skills are required. It might look at things like, you know, is it in a similar location? Is it working in the same setup? So you were working with the same number of people. If you were doing a job where you had a lot of autonomy, and then you were offered a job where you were one of a number of people and you had a lot more direction, that kind of thing would come into effect. So grade is certainly one of them. And employers tend to offer alternative employment on the same grade. Sometimes if you're offered a lower grade, you could get it red circled where they'll protect it for a certain number of years, and you hope that something else will come up in the meantime. So it does depend on a bit on the job itself. So for example, in healthcare, you had somebody who was working as a community matron. So her job was in the community, going around visiting people every day. She was offered a job in a small country hospital where they had about 12 beds. So it was pretty much the same work. She was still working with patients. The fundamental job was the same. It was the same money, the same grade. But it was such a different type of involvement that the tribunal said actually that wasn't suitable for her. So it depends on a lot of factors. And then there are the other part to that question is, once you've been offered the suitable alternative, you can reject it if you're reasonable in doing so. So there's some crossover between what's suitable and what's an unreasonable rejection of a job. So factors such as reasonableness will come down to personal circumstances, such as if you've got children in a local school and you're being asked to commute 15 miles each way, it could be reasonable for you to turn down the job. But the suitability tends to be the subjective factors about the job. Does it involve the same type of work? Is it a process? Is it a production process that you've done before? Status comes into it as well. That can be seen as a bit subjective. People can think that well, certainly in a management role, you would expect to have a similar number of reportees. For example, if you're a manager and you're given a job where you don't have to line manage anybody, that would be a factor that made it unsuitable. It's anything really that's status, type of work, type of environment you work in, what sort of responsibility you have, all those things go towards it. And grade is one, and sometimes employers won't offer lower grade jobs unless you ask for it. So it is important, if you're representing somebody who's looking for alternative employment, get them to say specifically what they would consider, because it could be there are circumstances in which somebody might say, well, I've been fancying a career change for a while. I would take a lower grade job because it would develop my skills and it would be a chance to go in a slightly different direction. But the employer might not offer it because they might think it's not something that would be considered. So it's worthwhile having a very detailed discussion with members about what they would and wouldn't take, and just try and push as much as possible, because if some employers have got sort of quite narrow criteria, some of them even do it on, they have like an automatic job matching scheme that picks certain criteria and matches it. So it is something that's worth raising, and the earlier you raise it, the better, because you don't want to get to a point where there is another job and you've missed the opportunity, and then your member says to you, well, oh, actually, if I'd been offered that, I would have taken it. So it should be an early part of the discussion in the consultation.
That's really helpful, Sally. Thank you. And I think that that issue there of talk to your members, find out what they want individually. Like Sally says, they might be wanting a change, and it's always helpful to know that going forward. Equally important to push the employer on these issues. Try and get them to be as sort of broad and flexible about these things as we can. Okay, so Sally, you talked a lot about what redundancy is, what it can look like, but we've had quite a few questions about the differences between redundancies and restructures, especially if a restructure might be small and multiple, so it kind of exists as a separate exercise each time, so it goes slightly under the radar. What do reps need to be aware of in those situations, and what sort of things should they be looking out for according to the law?
Okay, so in terms of redundancy law, there isn't actually a definition of restructure or reorganisation. So it's either going to be a redundancy or it's going to be a change to terms and conditions, which is basically you're looking down sort of breach of contract, sort of fire and rehire type thing. With a redundancy, it's always about the number of employees. So are they looking to reduce the number of employees? If they are, then it's a redundancy. So if you remember the Burrell case, the Safeway and Burrell case, that's a really useful case to go back to, because the EAT is clear there that's saying the focus has to be on the employees, and we do get bogged down in the jobs because it gets really confusing when employers are restructuring whole departments and you're not quite clear which jobs still exist and which bits don't. But you need to look at how many employees have they got doing those jobs, and if they're going to end up with fewer, then that is a redundancy. And it's hard to see what's going on, like you say, especially large public sector organisations. They do this sort of constant round of restructures and reorganisation, and it's quite hard to keep track of. But you essentially have to map it out. Okay, what are employees doing now? How many employees are going to be doing the work in this new thing? Is that going to be the same number or not? And what is the job? So, you know, you go back to the heating and plumbing thing. So if we have a plumber who's now a heating engineer, that's a redundancy because they don't need a plumber anymore, they need a heating engineer. So that's the kind of process that you have to do. But there isn't an independent law that relates to restructuring. And if there's no redundancy, then you're looking at challenging it as a fundamental change to terms and conditions. And you know, employers can be aware of that as well, and they try and change things in sort of like little steps to try and sort of lost the screen then, to try and sort of coax these changes along. But yeah, it is down to the number of employees to do the type of work, essentially.
That's helpful, Sally. Thank you. And yeah, maybe something you can look out for, especially if you think your employer is deliberately flying under the radar there with multiple small restructures. Right, so on the subject of small redundancy situations, restructures, in a situation where there's no right to a collective consultation, what employment rights, if any, would you say give union reps the most leverage?
So in terms of what you can argue for in challenging the redundancy,
if there's no right to a collective consultation, if it's a small group of individuals.
Yeah, so it's the case law on unfair redundancy, basically, and it's anything from that Maxim case onwards. So, and it's really making clear to the employer, if you need to be taking these 7 steps. you know, in order to make this redundancy fair, you haven't done X, Y, Z. So we are going to be looking at a tribunal claim if you can't follow those. So the alternative employment is a key one as well, because they shouldn't just be, you know, looking, you know, here and now. Is there anything already established here today? I mean, there's no obligation on an employer usually to go out and find another job for somebody, although in occasional circumstances there actually are. There's a case where it's the Randall and City College case, where because they'd done such an effective restructure and got rid of so many jobs, the tribunal said, well, basically they were left with a blank piece of paper, so they could create a job specifically for a disabled worker, and the fact that they didn't made his job unfair. So it is a question of looking at those cases where tribunals have found a redundancy dismissal to be unfair for a particular reason, and using that. So you can say, well, it's going to be unfair unless you do more to find alternatives to redundancy, then this is going to be unfair. Then you'll be looking at compensation on top of a redundancy payment, or, you know, like the COVID case of the care worker who was unfairly dismissed because they didn't offer her furlough first. There could be specific things in the workplace that could even just put off the redundancy for a while, because the argument then is, well, if you'd given them this, then 3 months down the line another job might have come up and they could have had that one. So it's trying to use these existing cases to put, you know, to really reinforce that they do have legal obligations and case law is relevant to them.
Thanks, Sally. And remember, we will be sending out the resource sheet that Sally's prepared, which gives some references and some details of the cases that she's talked about, so that you can either use this or you can look up further information about these situations to see if they apply in your workplace. Okay, so speaking of cases, have there been any cases that involve fire and rehire situations where permanent staff are replaced by people on fixed term contracts?
Gosh, then replaced by fire. I can't think of any. I can't think of names. But if you replace a permanent employee with an agency, that would be a redundancy situation, because because you're changing the category of employees. So the employer. So I think there is a particular case on that. I haven't got it on my sheet though. I'll have to look it up and see if I can add it. So replacing a permanent employee with agency staff or somebody on a contract is a redundancy, because there's no longer a requirement for a permanent member of a permanent employee. So that is that does make the definition of redundancy. And I think there is a case, but like I say, it's not on there. I'm going to have a look, see if I can find it.
That would be great. Sorry to put you on the spot, but that's if there was one, it would be great if it could be included.
Yeah.
Okay. Is there any way to challenge? Is there any way to challenge a total factory closure or the total closure of a workplace based on the argument that it's cheaper to manufacture abroad? And if so, what can a rep do, or what can the union do?
It's limited. I mean, basically, you probably, I mean, if there are fewer than 20 employees effective, then probably no, because the tribunal's not even going to look at reasons for making that decision. If you're in a collective situation, then there's an obligation to look at the economic circumstances, and the only real way that you could challenge it would be if you could find a way of rescuing the business, because employers are entitled to maximize their profits. That's how the law sees it. The only thing I could think of is if you had some sort of equality element to it, but you know, if it was a and then again, you'd probably only be looking at public sector equality duty. I think unfortunately there's nothing you can probably do about that.
Yeah, for sure. It's obviously an extreme example, but I thought I'd ask it because it could cover lots of different scenarios. Okay, you've talked a little bit about equality issues, and we know that they are key in redundancy situations. So what can you talk a little bit about disability specifically, and that a suitable alternative role might not be suitable because of that individual's disability? What might be the recourse in that situation be?
So the duty to make reasonable adjustments applies to redundancy, alternative working redundancies, as much to anything else. So employers would be expected to go over and above what they would do for non-disabled employees to try and find something that was suitable. So in that situation, if a disabled employee was made redundant, it depends whether if there were other jobs that they could have done, but somebody who was not disabled got the job instead of them, then you would have a discrimination claim, and the recourse would be through a discriminatory dismissal claim. So effectively, a disabled employee would have priority over what vacancies there were. I mean, if they were offered are you saying they were offered alternative work, but they were saying it wasn't suitable because of their disability, so they needed an adjustment?
I think so, yeah.
I think so. Yeah, so certainly whatever alternative is offered, if it's to a disabled employee, the employer has a duty to make adjustments to that alternative. So it would be a question of seeing what adjustments need to be made so that they can effectively take that job.
So it's bringing together perhaps adjustments they had in their previous role and applying them to the new one. We at the TUC do have guidance for reps about reasonable adjustments passports. We will post a link to that in the chat, and we will include it in the resources email. So this idea that you have a reasonable adjustments agreement that then is passported through to different jobs. So we will definitely include information about that. Okay, we've had a question about settlement agreements. Sally, can you briefly tell us what's the difference between a settlement agreement and a redundancy package, and perhaps pros and cons of each? Just, a couple.
Right. Well, a redundancy package is something that you get because you have lost your job through redundancy. So if it's probably going to be better than statutory, but it doesn't have to be. So basically it would incorporate the statutory minimum redundancy pay, any notice. A settlement agreement is any agreement that compensates you for a loss of a job for any reason. Settlement agreements tend to be confidential, so an employer will generally want you to sign something to say that you're not going to disclose what's in it, and also they will probably be asking you to settle all claims against the employer. So that means you have to get legal advice anyway with a settlement agreement. That's the law, otherwise the agreement's invalid anyway. So, but you have to make sure that the member is absolutely clear about what they're settling, because it could be that they might have a claim, in 3 months' time that they're not aware of. That they could find out that the employer owes them loads of backdated holiday pay or something else. And so if you sign a settlement agreement that settles all claims, you won't be able to pursue a claim about anything in the future. So redundancy basically is specific to redundancy, whereas a settlement agreement can be for anything. It's not uncommon, especially for employers who offer enhanced redundancy pay. So it's quite a large, a much larger sum of money, and they tend to want confidentiality or settlement of other claims as well, because they don't want to have to come back and pay more for other claims.
That's really helpful. Thank you, Sally. And I think, is it worth adding here that it obviously includes, if you signed a settlement agreement, you've got no recourse to the employment tribunal about that, like ending of that job and that redundancy, for want of a better name.
Yeah.
Thanks. Okay. What's the deal with fixed term contracts? Do they the ending of a fixed term contract, does that constitute a redundancy?
Yeah, it does. So obviously you only get redundancy rights if you've been employed 2 years or more, but the end of a fixed term contract is a dismissal, and if it meets all the other criteria for redundancy, then it will be a redundancy.
Thank you. You talked in your one of your previous answers a little bit about awards and compensation. Now, I appreciate that this is a big area in itself, but can you cover a little bit what kind of awards people might get at a tribunal, and compensation if a redundancy was found to be unfair?
Okay, so a claim for unfair redundancy is basically an unfair dismissal claim. So you've got, it's one of the potentially fair reasons of dismissal. So you're claiming, there's probably going to be a fair reason, which is redundancy. So you would get a basic award and you get compensatory award. So the basic award for redundancy is exactly the same as the basic award for an unfair dismissal claim. So, sorry, statutory redundancy pay is exactly the same as the basic award for unfair dismissal, and you get one or the other. You don't get both. So if you've already had a redundancy pay, you won't get a basic award for unfair dismissal, but you would still get the compensatory award. And the compensatory award is designed to compensate you for the loss of your earnings up until the time that you find another job, but it's capped a year, or I can't think of the figure off the top of my head. Some of the reps here will probably know. So it's capped at a weekly sum, and it's also capped at a total amount of what you can get. It's important, if you're thinking about challenging this, if you think that actually redundancy was not the real reason for dismissal, then you have to challenge the reason as well. So you can either put in a claim saying that you accept it's a redundancy dismissal, but you think the procedure was unfair, so it's an unfair dismissal claim, or you can challenge both and state that you don't think that redundancy was the real reason for dismissal, that you think it's you were selected because you were union rep, for instance, in which case the award would be unlimited anyway.
Thank you. Yeah, it's obviously going to be different in every situation, but it's really helpful to have that kind of general formula that's applied. Okay, trial periods in suitable alternative employment posts. Are they really trials? Do employees get much leeway in that? How can they how can they negotiate really? Could they get changes made? What's the deal?
Well, you can, I think, like I said about the other case that I was dealt with before, it's important to do it, especially if you think that it's not actually suitable, because if you don't do the trial, it's much harder to prove it. But you do have to make sure that you let them know if it's not suitable, as soon as you need to. But I mean, certainly employers will probably try and force employees into doing a trial if they don't want to pay them redundancy pay. So in that sense, I suppose you haven't got much choice in doing it, and I think it would probably damage you in a tribunal claim if you didn't take a trial and then you tried to argue that the alternative wasn't suitable for you. So I mean, it also actually gives you an extra 4 weeks in employment so that you could carry on during that time, forcing the employer to look for alternative employment as well. So there are ways you can use it to your advantage.
Thank you. And that's also answered another question that someone asked about, should someone actually wants the redundancy pay, can they be forced into doing a suitable alternative post? Obviously, people can't, but you recommend that they do so that they could then have a claim.
Yeah, I think the danger is if they refuse to do the trial, they might lose their redundancy pay. So they really want to look very carefully at the reasons for not doing the trial, and if they think it's because it'll be found to be suitable. It's important to remember also that it's, there, as well as the suitability of the post, there is still this other step, which is about whether it's reasonable for you to refuse it. So even if a job is seen objectively as suitable because it's, so similar, there is still scope to say, but in my personal circumstances, it wouldn't be, it's reasonable for me to turn it down. I've mentioned before, it could be the location, there could be some particular reason that job doesn't suit you on a personal basis. So, remember that as well.
Thank you, Sally. I think we've gone through quite a lot of questions. We've had a lot posted, I'll admit, but we've answered, I think, a fair number of those. So I do think, our viewers, if I've tried to combine questions and make them generic and useful to all. We are very nearly at the end of our session today. So just before I ask Sally for some final tips, just a reminder really that the TUC also has further guidance on redundancy situations for workplace reps. We'll post a link to that. It's like some online guidance that you can look at in your own time. We'll make sure that you get the resource from Sally, which details the cases she's been talking about, which I think you've been here today with and can use it to show what you've learned. We have quite a few events coming up over the next few months from the TUC. We are going to have a session for reps about preventing burnout, specifically in the role as a union rep, because we know that you take on the problems of other people and that can be quite stressful in itself. So do sign up for that. We'll make sure we share the link. It's in mid-July. We are also going to be having another Union Reps Connect event in the autumn. Some of you came and met us. We're going to be having another event, many of you again in October. We will be advertising soon, so watch this space. So finally, Sally, what top 3 things would you say that reps should keep in mind if they've got a redundancy situation? If they don't remember anything else, what are the top 3 things?
Well, I think firstly, get involved at an early stage. Don't wait until the employer has come up with its final plan. You should be involved much before that, even though they won't want you to be. Secondly, go through the list of things that would make a redundancy unfair. Look at the case law, because that's going to be the areas where you've got the strongest challenge. And thirdly, just make sure you communicate with your members and make sure that they are aware this is a really good time to be building the branch, and your members on the ground are going to be in a crucial place to give you information, because you'll probably get more from them than you will from the employer when you're putting together your counter proposals.
Thanks, Sally. That's really sound advice. I think we can end on that. Thank you everyone for joining us today. You've been a great audience, and I look forward to seeing you all again soon.